Hi, I'm Greg Dell with attorneys Dell and Schaefer, and here with attorney Alex Palamara. And Alex, I got to tell you, in reviewing the case that we're going to discuss today, it feels like Groundhog's Day for me because about 25 minutes ago I filmed another video on a California case of an opinion that was also just issued recently. And this case that we're going to talk about for you was April 4th, 2018. It was a case against
Reliance Standard.
Reliance Standard, life insurance company. They all kind of mesh together when you deal with so many. And that case was also a claimant victory. And in your case, again, we have a claimant victory. It's a special. This one's actually really special. Not a case that we handled, but it's great that it was Reliance Standard because of basically of all the companies, they always tend to think that they're right and they like to be really cutthroat in litigation, as you know from our experience. So it's always fantastic to see Reliance Standard lose a case, which does happen often, but they don't have the volume of cases that a Unum, a Prudential, a Cigna, Hartford, Aetna, all of those other companies do. So give us some background about this case, and then let's go ahead and talk about the takeaways from this case that are going to benefit claimants nationwide moving forward.
Well, this case was great, and the judge in this case was great as well. And we'll get down to it, but the judge really took their reviews and their IMEs to task. The plaintiff is by the name of David Cochran. He worked in IT for a big company. He worked there for many years, was forced to make a claim because he suffered from chronic fatigue and fibromyalgia. So he was forced to make a claim in February of 2011. Reliance Standard took an initial look at the claim and actually approved the claim and paid benefits for a number of years, then denied the claim, had to go through the appeal process, back on claim, but ultimately denied in 2015. And after more appeals were filed, a lawsuit was filed. Now what makes this case so interesting, not only did the plaintiff win the case, but the judge, like I said earlier, kind of took the reviews that Reliance Standard relied upon, took them to task, heavily criticized them. And the judges, the first thing that the judge did is he looked at each one of the reviews and noticed that each one of the reviews required objective evidence, saying, hey, I looked at the reviewing doctor said, hey, take a look at this guy's medical records. I don't see any objective evidence of chronic fatigue and fibromyalgia. And the crazy part is, the reason why the judge took him to task is because there is no objective evidence for fibromyalgia or chronic fatigue. There's no test, there's no blood test that you can do. It's not something that there's any known test to affirmatively prove that someone's suffering from these disorders.
What is it about these doctors that Reliance Standard hires, and not just Reliance Standard, but all of these insurance companies, that allows a doctor who doesn't even examine the patient to be able to say, oh, there's no objective evidence, as if everyone are complete morons, like as if the courts don't know that there's no objective evidence for that, as if the claimant doesn't know there's no objective evidence for it. Maybe they think the claimants don't know and they read that and they say, okay, I needed to show objective evidence. I have a condition that doesn't have objective evidence, so I'm just going to not do anything about it.
I don't know why they rely upon these reviews, but I guess it's worked for years for them, So many times people denied claims based on these shoddy reviews, and the judges have been, handcuffed and have to uphold the denials. So I guess the insurance companies have just kind of gotten away with it, and they just feel comfortable doing it. And luckily, with all the litigation that we do and other law firms are doing, judges are becoming more aware of the reviews and how shoddy they can be at times. And why the doctors do shoddy reviews, I don't know. Some doctors do great reviews, but more often than not, we kind of see the same names and same doctors across the country doing the majority of the reviews, and these judges are finally realizing that some of these reviews are not worth the money that they paid for and the paper that they're written on.
And why do you think these insurance companies prefer to do the paper reviews and not actually have the claimant examined by a doctor?
Because it's so easy to criticize the Monday morning quarterback, the medical records that the treating physicians are writing, because you have to remember the treating physicians are not writing medical records to support a disability insurance claim. They're writing medical records to treat their clients. So when a Monday morning quarterback physician comes in and says, I don't see this, this, and this, and actually in this case at hand, one of the reviewing physicians said, I don't see any muscle atrophy here, so how could this person be suffering from fibromyalgia? And the judge took that to task because muscle atrophy is not a sign or symptom of fibromyalgia. So this guy's just writing words on paper to support his own opinion, and what he's using to support his own opinion has no water. There's no proof to this guy's opinion whatsoever.
It's this is a cycle that's been going on. It's not even a cycle because it doesn't come back around, but this is the MO of the insurance company to allow these doctors to keep offering these types of opinions in situations where you have only subjective evidence of disability. But let's just talk for a second about the sad reality of what went on for this claimant. Since 2011, initially disabled, on and off disability a few times, finally disabled, denied again in 2015, and now here we are, April of 2018, 3+ years later, and now there's finally a decision. But this claimant went 3 years with no benefits.
Can you imagine what his family went through financially and emotionally during that time period?
I mean, this is the game plan of the insurance company. Is we basically kind of know our denial is shoddy, not really strong, but we can kind of push their backs against the wall, deny them. They may or may not get a lawyer. They may be forced to go back to work, working in desperation pain. But even if not, maybe they sue us, then we offer them, 15 cents on the dollar, and maybe they'll settle. And that's the model, because if they're going to pay 15 cents on the dollar versus 100% of what this person's really entitled to, and they know that most people can't go 3 or 4 years to battle them, then they're going to keep doing this model knowing that they're wrong. It's a business for them. That's what they're doing, and it's sad. But fortunately, we're able to fight them every day and really try to win these cases at the appeal level, and they are winnable.
For sure.
As you know. So if you have a claim with Reliance or any other long-term disability insurance company, feel free to call any of our disability attorneys. We offer help at any stage of a claim. That means applying, on claim, appeals, lawsuits, even lump sum buyouts if you're interested in one. Any of our disability attorneys can help you. We offer our assistance anywhere in the country, and we look forward to speaking with you.